Hello, welcome back to my YouTube channel. For those of you who are seeing me for the first time, you can just subscribe this channel and go back to my previous videos. Maybe you'll get to know about me. So for today's topic, I would like to discuss about the Indian Mental Health Act, which is very important for all the psychiatric nurses who are working in psychiatric settings, and also for the students exam point of view, as well as for those who are doing their masters in mental health nursing. This is a very important aspect. Indian Mental Health Act 1987. So this act was drafted by the parliament in 1987, but it came into force or effect in the year 1993 in all states as well as union territories. But before this act, there used to be another act, Indian Lunacy Act of 1912. This act has been derived from English Lunacy Act. It has been derived from English Lunacy Act, and this Lunacy Act has been practiced in England. And there is a gap, huge gap between 1912 and 1997 or 1993 when it was implemented or came into force. So why this change has taken place? We need to know the reason. The reason is that the societal view towards the psychiatric conditions has changed. The attitude of the society towards the mentally ill has changed. Apart from that, there had been rapid advancement in the treatment aspects for the mentally ill conditions, increase in the knowledge, pharmacy as well as newer antipsychotics came, and apart from that we have ECTs, other psychological therapies. So due to advancement in all this scientific technology or medical technology, it became necessary for the Indian Lunacy Act to be modified. So coming to the Indian Mental Health Act definition, an act to consolidate and amend the law relating to the treatment and care of mentally ill person to make better provision with respect to their property and affairs and for the matters connected therewith or incidental thereto. Definition is very clear. It is pertaining or dealing with the laws related to the treatment and care of the mentally ill persons. And apart from that, to make better provisions in respect to their properties and affairs or all the matters which are connected to the mentally ill persons or any incidents which occur in regard to the mentally ill persons. This is the definition. And coming to these salient features of this act consists of 10 chapters. Then we said Indian Lunacy Act. Indian Lunacy Act, there are 8 chapters. And this Mental Health Act consists of 10 chapters and 98 sections. So in these sections we have description about these 10 chapters in detail. There is a book, Bare Act book of Indian Mental Health Act 1987. If you are interested, you can just purchase that book. You will get in full detail regarding this MHA 1987. And as said, this consists of 10 chapters. We will just see the gist of it, but later on we will just go in little detail about these 10 chapters. First chapter deals with the preliminaries of the act. So when we say preliminaries of the act, it deals with the terminologies and the qualifications in regard qualifications and the definitions of certain terminologies which are used or discussed in this MHA 1987. Chapter 2 deals with the establishment of mental health authorities at state as well as central level. So when we say authorities, they are appointed a committee is framed by different psychiatrists from different states. They are called, gathered, and they are appointed as authorities for the states, as well as from state they appoint authorities for the districts. There are different personals who carry different aspects. So it's a chapter 2 deals with the establishment of authorities at central as well as state level. Now coming to chapter 3 deals with the establishment as well as maintenance of psychiatric hospitals and nursing homes. 4 deals with the procedures of admission and detention or keeping the mentally ill persons in psychiatric hospital. Then 5 deals with the inspection, discharge, leave of absence or removal of mentally ill persons from the psychiatric hospitals. Then 6 deals with the judicial inquisition regarding alleged mentally ill persons possessing their property and their management. Chapter 7 deals with the maintenance of mentally ill persons in psychiatric hospitals or psychiatric nursing home. 8 deals with protection of human rights of the mentally ill person. 9 deals with the penalties and procedures for infringement of the guidelines of the Act. Suppose if there are any institutions or hospitals which are not following the rules or the guidelines or the regulations of this Act, then what type of action needs to be taken is clearly discussed in chapter 9. Then 10 deals with miscellaneous matters, other matters which are not covered in the other 9 chapters of this Act are covered in chapter 10. Now, coming to the objectives of this MHA 1987, as seen in these chapters, the objectives also are almost closely similar to that of these chapters. First one is to establish central and state authority for licensing, supervising psychiatric hospitals, then establish psychiatric hospitals and nursing homes, check the working of this hospital, to provide for the custody of the mentally ill persons who are unable to look for themselves and those who are dangerous for themselves as well as to the society. Then to protect the society from dangerous manifestations of mentally ill, to regulate the procedure of admission as well as discharge of mentally ill, to safeguard their rights, to protect the citizens from being detained in mentally ill hospitals or psychiatric hospital unnecessarily. If it is necessary, only the person needs to be hospitalized. Other than that, the person can be discharged back to the community and can have treatment. Then the 9th objective is to provide the maintenance charges of mentally ill persons, to provide legal aid to poor mentally ill criminals at the state expenses, to change offensive terminologies of Indian Lunacy Act to newer soother ones. So these are various objectives of Mental Health Act 1987. Now coming to the chapters in little bit detailed. Anyway, we won't be able to cover in full detail form because I said there is a separate book for this act. We will just have an understanding. Chapter 1 we said like preliminary, the terminologies are, offensive terminologies are changed or modified to the newer soothing ones. From this we see like district court, the definition of district court, it is a city civil court or the principal city civil court of original jurisdiction, or any other civil court which is competent to deal with the matters related to this act, Mental Health Act, is called as a district court. Then we also said there will be inspections for psychiatric hospitals as well as nursing homes. So we need inspecting officers. So the term inspecting officer means a person authorized by the state government or by the licensing authority to inspect any psychiatric hospital or psychiatric nursing home. Next, coming to license, means license granted under section 8. Next, licensee means the holder of the license. Magistrate metropolitan magistrate or the chief judicial magistrate, subdivisional judicial magistrate, or such as judicial magistrate of the first class. They can be MROs, Mandal Revenue Officers. They are also called as magistrates. Then coming to medical officer, he is a gazetted person, medical officer in the service of the government. And we say government, it might be central as well as state. Coming to mentally ill person, means a person who is in need of treatment by person of many mental disorder other than mental retardation. We call them as mentally ill person. So from this, mental retardation has been excluded. Please note this. Next, coming to minor. You all know who is called as a minor. Any person below the age of 18 years, we call them as minors. Next, coming to mentally ill prisoner. Is a mentally ill person ordered for detention in a psychiatric hospital or jail or other person of safe custody, he is called as a mentally ill prisoner. Next, coming to psychiatric hospital or nursing home. Hospital or a nursing home established or maintained by the government or any other person for the treatment and care of the mentally ill is called as a psychiatric home. For example, some of the previously used terminologies, how they are modified, you can have a glance of it. Before, psychiatric hospitals were called as asylums. And the mentally ill person was called as lunatic. Mentally ill prisoner is called as criminal lunatic. So like this, there are so many terminologies which have been modified and they are discussed. Now coming to the second chapter. As said, it deals with the various procedures for establishment of mental health authorities at state level as well as central level. There will be an expert committee where they gather and they try to appoint various authorities to deal with inspection, for establishment of psychiatric hospitals, for framing certain guidelines, rules and regulations, for expenses, financial, for taking care of financial aspects. All these, the authorities are appointed from the central as well as state levels. So chapter 2 deals, it provides certain guidelines how to do that. Coming to central authority, shall be subject to the superintendent's direction and control of the central government, as said, and shall be in charge of regulation, development and direction and coordination with respect to the mental health services under central government, supervise the hospital, nursing homes, mental health service agencies under the control of central government, then advise the central government on all matters relating to mental health. These are certain responsibilities of the central authorities. Then similar to that of state authority also does this. It also carries the same responsibilities, subject to superintendent's direction and control of state government. Then also for regulation, development and direction and coordination in respect to the mental health services under state government, then supervising the psychiatric hospital, home, nursing homes under state government. Then it provides advice to the state government in aspects related to the mental health. Now coming to chapter 3, psychiatric hospitals and psychiatric nursing homes establishment. This chapter 3 provides guidelines in maintenance and establishment of the psychiatric hospitals as well as nursing homes and provision of licensing authorities. The process of applying for license, how they get the license and how psychiatric hospitals are supposed to be framed, including the infrastructure and the staff or the manpower and the standards, rules and regulations and the employees, etc. All these details are discussed under chapter 3 of Mental Health Act. Now coming to the central government, it may be established or maintained psychiatric hospital or nursing homes for admission and care of mentally ill persons. And there are separate psychiatric hospitals which may be established and maintained for those under age of 16 years. And for those who are addicted or any not only alcohol or any other substances also, we can have a separate units. We call them as a de-addiction unit. Sometimes for below age of 16 years we call juvenile homes or Boston homes. Then those who have been convicted of any offense. Next, coming to the license. No person shall establish or maintain a psychiatric hospital or nursing home unless he holds a valid license. Either it should be granted by central government or state government. Application for license. A person, whoever intends to establish or to maintain a psychiatric home, should have a valid license, and he has to make an application to the concerned authority, either state or central, and see that the grant of license has been given or license has been granted. And this license is not transferable or heritable. And this license, once it is given, it is valid for 5 years from the date which it has been granted. Next, coming to chapter 4. This is very important because a question does come from the board regarding admission and discharge of the psychiatric patients in psychiatric hospital. So patients are admitted, or mentally ill persons are admitted into psychiatric hospitals under voluntary basis, under special circumstances, and on reception orders. Admission on voluntary basis. So here the major decision is taken by the patient himself, where a person willingly comes to the psychiatric hospital and says that I am not feeling well or not feeling well mentally, so kindly admit and request for a treatment. Or there will be a request by the guardian for the admission into the ward. So on receipt of the request, the medical officer in charge, he will make an inquiry within a period of 24 hours, and if he is satisfied, he will admit the patient. So such a patient who is admitted voluntarily, he should abide by the rules and regulations as may be made by the medical officer. Discharge of voluntary basis is also the similar. The medical officer in charge, on the request made by the voluntary patient or the guardian, if he is a minor, can discharge the patient within 24 hours on recipient of such a request. If the medical officer is satisfied and if he finds it is safe for the person to get discharged, he will consider the request of the patient, and within 72 hours of the request, he will constitute a board consisting of 2 medical officers seeking their opinion regarding the further treatment after discharge, and he decides on discharge, and he also writes, the medical officer also writes the treatment after discharge for a period not exceeding 90 days at a time, which means 3 months. And the patient has to come for the review or the checkup for this condition. Next, coming to admission under special circumstances. Here, any mentally ill person who does not or unable to express his willingness for admission may be admitted or kept as an inpatient in psychiatric hospital on application which is made on behalf of the patient by the friend or relative of the mentally ill person. So the person or the patient or the mentally ill person, when he lacks the capacity or is not willing to get admitted, during this time relative or the friend can make a request to the medical officer. And the medical officer, whoever is in charge, if he is satisfied that the person needs or requires an admission, can admit the patient. Next, admission on reception orders. So here we have receptions which can be made by the medical officer in charge or the spouse or the relative of the mentally ill, where the medical officer in charge is satisfied that the treatment in the psychiatric hospital is required to be continued for more than 6 months, and it is in the interest of the health and safety of the mentally ill person or protecting society or others from this person, also admissions can be made. In case of the persons who have been wandering on the roads or the streets, or who is found to be threat to the society or harmful to himself or to the others, an application can be made to the magistrate, we said first class magistrate, within the local limits of jurisdiction of the psychiatric hospital. And every application shall be signed and verified in a prescribed manner, should be accompanied by 2 medical certificates regarding the illness of the mentally ill person, and from 2 medical practitioners, of whom one shall be serving in the government. Duties of police officers in respect to certain mentally ill persons. Every officer in charge of the police station may take into protection any person found wandering within the limits of a station, and whom he believes that this person is not mentally sound, or he is incapable of taking himself, or is dangerous to the society or to the other persons, or self-harm. The police has the right to take that person into custody, and the police in charge of the police station can make a request. So no person shall be detained without being informed his relatives or friends, if any. Every person shall be produced before the magistrate within a period of 24 hours. So the police can take into control, but within 24 hours he is supposed to produce this person in front of the magistrate. Admission after inquisition. If any district court holding an inquisition regarding any person who is found to be mentally ill, they can make a request. By such order, the person can be admitted and kept in hospital. So the district court itself can give an order for the person to be admitted either for assessment or for treatment. Admission and detention of the mentally ill prisoner. So according to section 30 of the Prisoners Act, section 330 or section 335 of the Code of the Criminal Procedure 1973, directing the reception of mentally ill shall be sufficient authority for the admission of such person into psychiatric hospital. So there are different sections for this mentally ill prisoners. If they are found to have some mentally ill symptoms, they can be admitted in psychiatric hospitals under these sections for the treatment. Coming to chapter 5, inspection, discharge and leave of absence and removal of mentally ill persons from the hospitals. First one, inspection. Not less than 3 visitors shall at least once in every month. So individual person can have 3 visitors once in every month. Make a joint inspection of every part of the hospital, and they should enter their names into the register, and they can give their remarks regarding the management. And these visitors can give remarks, but they cannot inspect the personal records of the patient. This is regarding the inspection. Coming to discharge. Discharge by medical officer, discharge on application, discharge on request, and discharge of person subsequently found on inquisition to be of sound mind. We shall just see. Discharge by medical officer. When we say discharge by medical officer, recommendation of two medical practitioners. One of them should be definitely a psychiatrist. By order in writing, the medical officer shall direct the discharge of any person other than voluntary patient. So, during discharge, two medical practitioners have to take this opportunity, and one is a psychiatrist. And if they find that the person is sound enough to go back to the community and have treatment, they have to jot the same thing down put them the same thing on the order. Discharge on application. Here what happens, the person whoever is detained or admitted in the psychiatric hospital under the order can be discharged on the application made in that behalf to the medical officer in charge. So if it is from the court, maybe they can make an order, or if the person is admitted by a relative, maybe they can make an application to the medical officer. So here this can be applicable provided that no person shall be discharged if the medical officer in charge certifies in writing the person is dangerous and unfit to be at large. So if the application is made by the relative, friend, or from wherever it is up to the medical officer in charge to assess the condition of the mentally ill person and then decide whether to discharge that patient or not. Then discharge on request. Any person not mentally ill prisoner, okay, detained in pursuance of an order, if he feels that he has recovered from the mental illness, can make an application to the magistrate for the discharge of this mentally ill person from psychiatric hospital. And the application shall be supported by the certificate either from the medical officer or from the psychiatrist. Magistrate, after making such an inquiry, if he seems or if he deems that the person is fit, then can dismiss the application on discharging. Discharge of person subsequently found on inquisition to be of sound mind. Suppose if any person detained in psychiatric hospital in pursuance of reception order on inquisition to be found as sound mind, and if he is capable of taking care of himself and managing his own affairs or activities, daily activities, then the medical officer in charge shall discharge the person from such a hospital. Leave of absence. This is a temporary leave where the relative or the family members of the patient can apply, or patient himself can apply for leave of absence to the medical officer in charge. So this application should be accompanied by a bond undertaking that they will take proper care of the mentally ill person, prevent mentally ill person from causing any injury to himself or to the others, and will bring back the mentally ill person to the psychiatric hospital on expiry of the leave. Medical officer in charge may grant leave of absence for such period as deemed for a period of 60 days, totally 60 days. So this period is very important. For 60 days medical officer can give leave, and after the expiry of this leave, whoever it is, the family member, relative, or the patient himself, whoever has taken this person from the hospital, need to bring back the person and see that the person does not harm himself or others, and see that they take proper care of this person, especially the treatment aspects as well as nutritional aspects. Next, coming to removal. Any mentally ill person other than voluntary patient subject to any general or special order of the state government can be removed from the psychiatric hospital within the state or any state with the consent of the government of the other than the other state. Any mentally ill person other than voluntary patient, whoever is admitted under the special order of the state government, can be removed from one psychiatric hospital or psychiatric nursing home to another psychiatric hospital, in specially like it is like a referral. Next, coming to chapter 6. So the important aspects in this, like as I said, like admission and discharge of the patient is very important. Chapter 6 deals with judicial inquiry. It is all related to property aspects of the person and management of the property. These mentally ill patients have their right to just safeguard themselves and to preserve their properties. They can appeal to court to appoint a manager or a guardian who can take care of their properties. Then coming to chapter 7, it deals mainly with the cost and maintenance of mentally ill persons who are detained in psychiatric hospital, especially their food, whatever treatment costs, medicine costs, their the infrastructure of the hospital, and various aspects regarding the linen aspects and diet aspects, treatment aspects, and various therapy aspects. All these costs are taken care by the state government or the central government, and chapter 7 explains regarding that. Chapter 8, this provides information regarding protecting the rights of the mentally ill person. For example, some of the rights of the mentally ill persons are they are supposed to be treated with due respect and dignity, and the treatment has to be informed and it has to be with the consent of the person. Apart from that, mentally ill persons are not supposed to be used for any research purposes unless the research is providing some benefit, is of some benefit to him. At the same time, without the consent of the patient, they are not supposed to be used for research. Then regarding communication, whatever they have the right to receive, any communications, any envelopes or telephones or phone calls, or write a letter or send a letter. And apart from that also we have other rights, like they have the right for personal space, right for refusing ECT, right for talking to the relatives and talking over the phone. So there are different rights. Right for privacy is there, privacy and confidentiality, etc. Now coming to chapter 10, it deals with the miscellaneous aspects, we said. It deals with the procedures to be followed for the establishment and maintenance of psychiatric hospitals and nursing homes, and the penalties, which can be relatively severe or explicit, like anyone who is not maintaining the standards, rules and regulations. So all the other aspects are dealt in chapter 10. So I hope you have understood regarding this chapter 10. If you haven't understood, or if you have any doubts regarding that, please do just put a text in comment box so that I'll be able to respond to you. That's all for now. Thank you all very much. We'll get back soon. Please don't forget to subscribe and share this channel. Bye.